Welcome to Law Reading Channel. Today I will read episode 1.12 from Article 146 to 159. Let's go. Article 146. Artisanal and small-scale mining. The ministry or institution responsible for mines or subnational administration shall develop legal instruments on artisanal and small-scale mining to a. Determine artisanal and small-scale mining rights of citizens. B. Ensure environmentally sustainable, safe, and efficient artisanal and small-scale mining activities. C. Promote and apply international best standards and practices in the management of artisanal and small-scale mining. D. Establish a process for designating areas for artisanal mining in consultation with local communities and other stakeholders. E. Require and assist artisanal miners to develop and implement a safety and security plan. Article 147. Avoidance of environmental harm. Project owners shall avoid causing pollution or severe environmental harm by utilizing the best available technology and best practices to enhance maximum efficiency during extractive industry activities. Article 148. Obligation to provide a permit for the use of cyanide and mercury. Gold and silver mining project owners shall provide documents to the ministry responsible for environment and natural resources via the ministry or institution responsible for mines to certify that the use of cyanide and mercury gold and silver mining operation has been purchased safely and does not affect the environment. Article 149. Requirement for the use of cyanide and mercury. For the use of cyanide and mercury in gold and silver mining projects, project owners shall ensure that the storehouse of these substances is safe and does not affect the environment. In compliance with legal instruments governing cyanide and mercury. Book 3. Environmental Protection. Section 1. General Principles for Environmental Protection. Chapter 1. General Provisions. Article 150. Purpose. This section aims to strengthen waste management effectiveness, protection, prevention, and reduction of environmental pollution by defining general principles for obligations and responsibilities and defining implementation measures for waste, pollutant, and environmental pollution management towards protecting public health and environmental quality. Article 151. Scope. This section applies to all waste and pollutant management activities and environmental pollution protection, prevention, and reduction activities. Chapter 2. Responsible Institutions. Article 152. Responsible Ministries or Institutions. The ministry responsible for environment and natural resources shall undertake environmental protection to protect, prevent, and reduce environmental pollution and public health impacts. Article 153. Roles and duties of the ministry responsible for environment and natural resources. The ministry responsible for environment and natural resources shall have the following roles and duties. A. Develop draft policies, strategic plans, legal instruments, action plans, and guidelines concerning environmental protection. B. Coordinate with relevant ministries or institutions and subnational administration in the implementation of policies, strategic plans, legal instruments, and action plans concerning environmental protection. Implementing precautionary plans and emergency response in cases of environmental pollution dangers and environmental quality restoration. C. Manage environment, water, soil, air quality data and pollution source, waste, pollutant, data and electromagnetic data. D. Control and inspect the sites or means of production, commercial activities or services related to generation, production, consumption, processing, exploitation, treatment, discharge and final handling of waste, pollutants, noise release, vibration, and electromagnetics, including monitoring the implementation of investment projects. Environmental pollution management plans. E. Review and provide technical comments on environmental protection on public and private investment projects. F. Study, research, and assess the chemical release into the environment, assess the level of environmental pollution and impact on public health. G. Provide guidance and technical support, resources, and means to subnational administration concerning the management of solid waste and urban wastewater, as well as monitor and evaluate the implementation by subnational administration. H. Manage the delivery of public services related to environmental protection and environmental laboratory services. I. Motivate and encourage investment and resource mobilization for environmental protection, waste management, pollution prevention, and environmental quality restoration. J. Develop environmental protection capacity for provincial and municipal departments of environment and relevant subnational administration units. K. Fulfill the duty as a national focal point to promote and coordinate the implementation of international instruments and cooperation with national and international development partners concerning environmental protection. Chapter 3. Waste Management Obligation. Article 154. Waste Management Obligation. All citizens shall be obliged to be responsible for waste management as determined by the ministry responsible for the environment, natural resources, and subnational administration. Article 155. Obligation for waste fee payment. All citizens shall be obligated to pay collection, transportation, treatment, and handling fees, as determined by the ministry responsible for environment and natural resources and subnational administration. Article 156. Waste Discharge Standard Compliance. 1. Waste or pollutant discharge into the environment shall comply with waste discharge standards. 2. Persons who directly commit, give order, or facilitate an offense in contravention of paragraph 1 above shall be liable for Article 157. User fee setting. 1. The use of products or materials that may cause environmental risks, public health, or non-processable waste shall be required to set user fees for those products or materials. 2. Fees collected from the user fee setting shall be utilized to improve waste management and extraction. 3. The ministry responsible for environment and natural resources and the ministry or institution responsible for economy and finance shall develop legal instruments and enhance fee collection and management from user fee setting, as stated in paragraphs 1 and 2 above. Article 158. Liabilities of exclusive producers, importers, or suppliers. Individuals who exclusively produce, import, or supply equipment or consumer materials considered hazardous waste after usage shall be responsible for developing and implementing a collection system for tools, equipment, or consumer materials and returning them to the country of origin or to be treated, processed, eradicated locally without causing environmental or public health dangers. Article 159. Prohibition of illegal waste disposal. 1. Disposal, discharge, or eradication of waste in violation of provisions of this code or existing laws and legal instruments shall be prohibited. 2. Persons who directly commit, give order, or facilitate an offense in contravention of paragraph 1 above shall be liable for such an offense. An offense. Thank you for reading with us and have a beautiful day and welcome to New Year 2025. We will meet in episode 1.13.